with them for help. So yeah, I wanted to provide just a little information. There's a lot of scams going on about in regards to Medicare with it being open enrollment. So, what else did I want? Oh, I know, Jill King.
Yes.
Hey, so Jill is, are you director? What's your title?
I'm a Just Serve Specialist.
Okay, and so if you're looking for volunteer opportunities, that is what Jill does. And she's started being a regular attendee, so looking again to have you come in and actually be a panelist. Unfortunately, we had it scheduled, but something came up and we had to cancel it. So, but if you are looking for volunteer opportunities, check in with Jill back there and she should be able to help you. So, how many first-time attendees do we have here today? Okay, well, welcome everybody. I'm glad you made it. Hope you enjoy it. Just a couple housekeeping things. We typically run pretty sharp on time. I left starting a few minutes late because of the parking situation. So we usually do not have this issue or this issue. Help.
I give you the remote for like 10 seconds.
I know, I break everything. Anyway, so we run from 10 to 11 o'clock with questions directly with our panelists, and then we open it up for questions, open Q&A. So we ask that you hold your questions till the end, otherwise we're not able to get through all the information that we've prepared for you today. We do have a no selling policy, but information is available for you after the program. So Sharon will have that information set out for you. And then we have notebooks if you're interested in attending next year. We have the calendars there. We have notebooks if you'd like one of those. Please let us know. We're happy to get one for you to keep your materials in. And today we have Sharon over there, teammate of mine, and then Dominic in the back helping out. Thank you, Dominic,
Always.
for all your help this morning. We just ask that you fill out the evaluation sheets. I really appreciate, even if you just jot a note down or two about ideas you have or what you thought about it. So today, our title is Asset Protection in Adult Children, Marvelous or Manipulative? Manipulative, that's hard to say. Okay. So, we have a few subjects to talk about, scenarios of proactive versus crisis planning, difference in legal docs, estate planning versus elder law attorneys. We're going to touch on asset protection. You'll hear things like community spouse, protection language, division of assets, penalty periods, which are known as look-backs, to qualify for Missouri Medicaid, family home exemption, revocable versus irrevocable trust. So to help us sort out this topic, we have a returning expert, Stephen Jones with Jones Elder Law. And so I'm thankful that you're here today. You've been in before. You've been a great resource. And we're glad to have you back. So you want to come on up and make yourself comfortable, or stand if you're more comfortable that way.
I would rather stand.
Okay, sure.
I sit all day.
All right. So tell us a little bit about your background, who you are, what you do.
Okay. So as she said, my name is Stephen Jones. I am the founder of Jones Elder Law. So I started my practice right out of law school at Bryan Cave, which is one of the big silk stocking firms in downtown St. Louis. And when I was at Bryan Cave, all I did there was what they call high net worth planning. So if you had $40 million or more, you came to Bryan Cave and we did your estate planning. What was unique about me is I'm not a trust fund kid. My parents weren't crazy wealthy, and I went to public school. So I was kind of an anomaly at Bryan Cave. But what that also means is I don't know anybody who has $40 million or more. which means I had no clients of my own. All my clients were Senator Danforth's friends or other partners' friends. And so somewhere along the way, I realized that this wasn't really my calling. This wasn't who I was meant to serve. And so what I did was I took the lessons and the information from working there, which was fantastic, and I applied it in the setting of the people that I'm comfortable with. The PE teachers, the pipe fitters, the people that do the day-to-day things, and said, okay, how do we take what I learned and make sure we protect these people for what's important to them? And so from that is where we came up with Jones Elder Law. And so what we have done for the past 15 plus years is work with middle of the road families and make sure that whatever their goals are, we help them achieve those. And if part of that is make sure that your assets don't get taken away, that's what we do.
So you work with average folks like us.
I am an average folk like you. I don't just work with them, I am one.
You am, okay.
So yes, I mean, it's our typical client is going to be a homeowner who saved some money for later in life, and now they're worried about, well, what happens? How do I make sure this gets to where I want it to go? Or even in the worst case scenario, if myself or my spouse gets sick, how do we make sure they don't take all this stuff away?
Okay, all right. Well, thank you so much for that
Thank you.
information. So can you give the audience an overview of the idea of seniors, estate planning, and, you know, we talked about, I titled part of it manipulation. I should have never used that word because I can't say it. By their children. How does that interrelate?
So I think what you have to kind of start with is foundationally, what is estate planning, okay? And estate planning is more than trying to avoid estate taxes. I think that's sometimes what people think. It's also planning for when things in your life change. Because what happens is, if we're going along and we're doing great, we don't really need anybody to help us with anything. But a lot of times we'll reach points where either physically or cognitively, we're not able to do things anymore. And so when that happens, there's two paths to that, okay? One path is you have set up your estate plan and you have things like a financial power of attorney, a healthcare power of attorney, possibly a revocable trust. And in those documents, you've done what I call created your roadmap. And you've spelled out exactly who's going to take over and start doing things when you can't, okay? If you don't do that, and this is the real risk for a lot of people that they don't recognize, then you don't have anybody set up to do that. And the law does not presume that your spouse or your children or your best friend or anyone else can make decisions for you. So if you don't have those documents in place, then you've got a problem. When you can't do it for yourself, you kind of hit a dead zone where nobody can start helping you. And that's when you end up going into the court system, and that's not usually desirable from a time and cost standpoint. So how does that all relate back to this idea of children and the possibility of manipulative children? When you're setting out who you want to be making these decisions for you, in most cases, people are going to first look to their children, okay? And if, God willing, you have good kids, it's easy. But unfortunately, not everybody's that lucky. Some people don't have that type of child. And so there are instances where it would not be a good choice to place a particular child over your decision making, because they may not be capable of doing that in the way that would be in your best interest. And so the conflux of all this is that when you're doing this planning, you have to be thinking about who is it that you trust to be doing these things. And so a lot of times it will be your child, but in many instances it may not be.
Okay, we're going to talk about some specific examples of
Sure.
things you may have never even thought of, as far as that goes, risks and things that can happen you never thought of. So you're speaking of proactive planning here.
Yeah, I think one of the best ways in my mind to really protect yourself is to get out ahead of things, okay? Reactive planning comes with its own set of problems because you may not be able to do the things you need to do. So my personal opinion is that anybody in this room, and I'm assuming most of us are over 18, you need to have in place financial powers of attorney, healthcare powers of attorney, and you need to have named a series of people so that if you reach a point where you can't handle your affairs, they can do so for you, okay? If you don't do that, you run into huge problems. What happens is when you don't have that document in place, if you become unable to handle your affairs, your bills don't get paid, your checkbook doesn't get balanced, your money doesn't get moved around. And so now you're in a position to where if your daughter or your son or whoever, your best friend, goes and says to the bank, I need to do some of this, their answer is going to be, do you have power of attorney? And if you say no, that's it. They're not talking to them anymore. So that proactive is about taking care of yourself and making sure that when you get to that point, and I'm talking about you're still here, you're alive, you're going to have your plan in place, your roadmap, so to speak, so that you don't have those hiccups. And one of the things I think that most people really don't understand is that if you don't do those powers of attorney, even if you're a married couple, your spouse does not have the right to make decisions for you. So if you take my case, my dad retired at 55, he played golf, and at 68, he developed a brain tumor. And he went from playing golf 4 or 5 days a week to boom, in the hospital, couldn't move, paralyzed all but his left hand. It affected his speech. And so my mom had to rely upon his IRA as a single source of extra money when they needed it. Here's the problem. If my mom needed $10,000, can she call up the IRA that my dad had created when he worked and get it out? The answer is no. The first question they're going to ask her is, do you have power of attorney? If she says no, they're done talking to her. And that's the end of the process. So you want to have that pre-planning done. And I think it is the single biggest way to protect yourself, because if you don't do it, you end up in court, okay? And let's say that you're like a lot of people and you kind of put off doing it because you're just not really comfortable with maybe a child or you don't want to make the decision between two children. Well, now what happens is when it goes to court, you don't have any control in it anymore. The court decides. And the very child you may not have wanted to be in charge of things may get appointed in charge of things. And you could be in the position that you were trying to avoid from the beginning.
Yeah, so,
I just had a question about the power of attorney. So when they ask you, do you have power of attorney, how do you prove you do? I mean,
Bring it in.
You're in the documents with you?
You send it to them. They're gonna tell you how they want it. Our clients have both their originals, and we typically will provide them a PDF of it if they want, which is a digital file. Some places will say, just send me a copy. Other places will say, fax me a copy. Others will take it electronically, and you can email them that PDF. But they're going to tell you how you need to provide it to them.
right, yeah. Some places make you actually bring the original, one of the originals in.
Yeah, I mean, it depends on every
Right.
institution has their own rules.
Right.
So it's more an institutional based stat as to how you do it as opposed to how the document is required.
Mhm. So, up on the slide, we talk about, choose how important it is to choose the right decision maker. And then can you speak to a couple things that maybe helps determine who would be a good decision maker for
Sure.
you to put in your power of attorneys?
So I start with the fact that when I meet with a family and we're talking about planning, I think sometimes they feel like they have to justify things. Like, here's who I'm picking and here's why. You don't have to, okay? That's not something that I'm ever thinking about. But what I'm always telling people is you should be picking the person that you trust, okay? Now, if that's your child, fantastic. If it's not your child, doesn't matter, okay? Pick who you trust. And so it goes back to, I think, this shared vision and values. So you have to start with, what are your goals? What is it you're trying to do? So if I was picking someone who was going to serve in a financial decision-making capacity for me, and I had the way I like to do things, let's say I'm very conservative, I don't spend a lot of money, I don't, make frivolous, quick decisions. Well, if I have a child who I love to death, but doesn't share any of those same traits, that's not a good child to put in charge of your money, because they're not going to change their basic course, the way they behave, just because you put them over your money, all right? A lot of times you'll have a child who doesn't balance their checkbook, doesn't really keep track of their money very closely. If you make them your power of attorney, they're not going to balance your checkbook, and they're not going to keep track of your money. And so in those instances, they wouldn't be a good candidate for making those types of decisions. So I'm not even talking about a fear of someone taking things or stealing from you. I'm just talking about fundamentally, when you aren't able to do this, you don't want to suddenly have to worry about, oh man, I see that I bounced 2 checks last month. Well, that would be very uncomfortable for someone who prides themselves in being very organized, very detail-oriented, and getting things paid promptly. So you don't want to pick the person who wouldn't follow through on that type of stuff. It does not matter who you pick. That is one of, I think, the biggest misconceptions. There's an idea that's been around probably for hundreds of years where you have to pick your oldest child or your oldest son. That's not necessarily the good answer, okay? If it's going to be a child, it should be a child that you trust and that you think has a shared vision and belief system that you do.
Yeah, exactly. And so what are some of the other options if you don't have, say, a family member?
So the options are really almost limitless. I mean, you could pick anybody you want. It could be a brother, it could be a sister, a niece, a nephew. It could be somebody that you go to church with. It could be your pastor. It could be somebody you play bunco with. It could be the person you're sitting next to right now. It's really a matter of who you're comfortable with. Because if you think about it, you're going to basically turn over very, very important decision making, okay? Either about your health care or about your financial matters. And so whoever it is, you really want to be comfortable with who they are and what they will likely do. And that's what's most important. So the relationship, are you a blood relative? Are you a friend? That's a lot less important than, is that person going to be making the right decisions? Now, in the worst case, and I say worst case from the sense of it being very expensive, you could go to a professional, okay? There are professional companies that handle trust. There are professionals that will handle financial powers of attorney and those types of things. But the cost of that is extremely high. And so in a lot of cases, economically, that is not a very good decision. So we rarely do that unless we don't have anybody that we could trust.
Okay, thank you. So let's talk about what is the standards for this person that you designate. So what are the legal standards? They're considered a fiduciary,
Correct.
right?
Yeah, I think that's one of the important things to understand is that when you are appointed as a power of attorney under a financial document, or you're appointed a trustee under a trust, or a personal representative under a will, you are held to what is called a fiduciary standard. That is a legal standard. That means that the individual has the highest duty to the person that appointed him. So if I'm Tom's trustee, I owe Tom a fiduciary duty, which means I should put Tom's interests ahead of mine in all my decision making. So think about this. I'm Tom's son, okay? And I'm managing his money. That would mean I should never entertain the idea that, well, maybe I shouldn't spend all Tom's money on his care because I want it. I should always be doing what's in Tom's best interest, okay? And that's the fiduciary standard. Now that's an important point because if I violate that standard, I can be held personally liable. That is the check and the balance when you appoint these individuals. Where this system falls down, though, is that what you want me to talk about that too? Yeah, where this system falls down, though, is by definition, if I start to take over for Tom, it's because Tom's having a problem. Tom's not able to do things as well. So the likelihood that Tom is going to be able to say, wait a minute, he's not doing what he's supposed to be doing is not as high. And so the enforcement of the fiduciary standard is where one of the issues that arises in this area. Because if Tom can't raise his hand and say, wait a minute, I'm looking at my account statements here and this isn't adding up, what's going on? Then who is? Well, the likely person that Tom expected to make that claim is probably the same person that he picked to be in charge, who's not going to make that claim against themselves. So enforcement of this can be a problem in these areas when there is something going on that's not quite right. Because you need somebody then externally who's going to say, wait a minute, they're not treating Tom right. And that's what some of the problem arises, as to who is going to do that.
So what about using multiple people then? You checks and balances or whatnot.
So as a general rule, we don't recommend multiple people, okay? And there's a number of reasons for that. The biggest one is there's a concept called impasse, okay? So let's say that Tom picks his son and daughter to be in charge of things, okay? And we are supposed to do things with a standard that's called independent authority. It means either one of us can do it. We don't have to talk, we don't have to agree, we just go do it, okay? And let's say that Stephanie decides to take an action and she goes in to do it and I show up and say, absolutely not, that's not what Tom wants. Well, what are they gonna do? The two people he picked to make decisions, one saying yes, one saying no. They're not gonna do anything. That's what's called an impasse. And so you create the possibility when you name more than one person that you can't get a decision. Same thing with medical. Do the surgery, don't do the surgery. One says yes, one says no. What do? And so that's a risk when you multiply the number of people that have that status as a decision maker, okay? The other thing that you run into is even though maybe we're supposed to be able to make decisions independently, because a lot of institutions are just more worried about getting in trouble themselves, they won't agree to it. And they'll make us do everything together. Now, why is that a problem? Because when you take over, you're taking over that person's life. We've got to pay his property taxes, his mortgage, his water bill, his power bill, his medicines, everything. So you're essentially taking on running that entire thing. Now, think about this. If we have to make decisions together, are we going to sit down every month and say, here's the power bill, it's $83.14. Do you want to pay it? Yeah, I think we should pay it. Okay, now let's go ahead and pay it. So you create this administrative burden and children don't like it. Okay, so we'll have people that come to us and they want to do more than one trustee because they don't want to hurt any of their other children's feelings. Okay, I will tell you that in those cases, we strongly encourage them against that. Because what we end up finding is that 20 years, 10 years down the road, when that child and their brother or sister are now doing this, they're not saying, oh, I'm so glad mom and dad didn't hurt our feelings. They're saying, this is ridiculous. Why do we have to get together and talk about everything? It takes so much time. So they're not happy with what was decided. They're unhappy with it. So you are better off in those situations knowing that it's easier and smoother to do it one at a time. Now, the one exception would be if I had no one, okay? So if Tom told me, I trust no one, my kids are not good, my brothers and sisters are worse, I don't have anybody I can put in charge of this that I would trust by themselves. Well, in that case, because of the ability to have that check and balance, so both of them would have to decide to do something wrong, then you might put two, okay? But that's a decision. He's thinking this through and he's saying, I know this is gonna be a risk of impasse, I know it's gonna cost more time and effort, but it's worth it from the standpoint of it gives me that additional protection because no one person gets off the reservation and starts to try to take everything.
Sure. So could you not make an argument that you should just skip the legal document process? I mean, there's an expense to it. And
sure.
You got emotions to deal with, so.
There is an argument to be made for that, and I think in some extreme cases, it's even possible that's the right answer. I think what we find in our practice is there's sort of a self-selection process. What I mean by that is the individuals that know they don't have anybody that they can really trust are probably never going to do any planning. because they can't even figure out how to pick someone. And so that self-selection process automatically forces them into where the court system's going to decide. So in that instance, if that individual becomes incapacitated, what's going to happen is there's going to be a conservator action filed, okay? The conservator action is something in court where the court is going to decide who's going to make your financial decisions, who's going to make your healthcare decisions. Now, that is insanely expensive, and you have no idea what's going to happen. It may be somebody you wanted, it may be somebody you don't know, it may be anybody. The court decides all that. The other problem that I think people don't anticipate is when you do your legal planning, it is a much easier thing to bounce in and out of. So let's say, and I hate to keep picking on Tom, but since I've met him, I'm more comfortable with it. In Tom's case, he goes through a bout where he's having some health problems. And so for about 12 months, he's not able to really do things. Okay, everybody with me? At the end of that 12 months, though, they've got him back to feeling good, he's doing well, and now he's really capable of doing it, and he doesn't really want anybody doing it. In a power of attorney, that would work. The power of attorney would step in, handle things for 12 months. Tom would say, I got this, go back to doing what you're doing, and he can take back over. That's not how it works in a conservatorship. Under a conservatorship, the court makes a fundamental decision to strip Tom of all of his decision-making rights. They're gone. He can't make decisions anymore. And so now what happens? Tom gets to doing better, doesn't get to start making his decisions. He would have to go back to court and seek to restore his decision-making authority, which is not going to be pleasant because the first time to go through conservatorship is probably going to cost you somewhere between $10,000 and $30,000, and to go back and get your powers restored is probably going to be at least 10. So I'll tell you how bad conservatorship is. We don't do it. You couldn't pay us to do it, okay? And the reason for that is we get most of our business from somebody saying, I liked him, he was nice, he did a good job. When you get done with conservatorship, it's like divorce law. Everybody's mad at the attorney because you paid a whole lot of money to make decisions for your husband or your son or daughter or somebody, and now they're not happy about it because they feel like that was the attorney's fault. It's the rules, I can't fix it, but the easy way for me to avoid it is we just won't do it.
If I run something with a company, governmental, I can be the executive, but I'm always audited. Somebody is looking over saying that. If you have two kids, can one be the executive and the other be or crooked anyway? I would think somebody should be looking over somebody's shoulder, not have two people steering the car, but somebody reading the road map.
So, yes, I mean, there's no official position, okay? So it's not like when you set up a power of attorney, here's who the power of attorney is, and here's who the power of attorney supervisor is. That doesn't really exist. But just by its very nature, the child is generally going to be, both children are generally going to be the beneficiaries of the trust or the will and that, so they have rights. And so they would be able to ask for information and supervise. Now, the issue with that is going to be as long as that child is a upright, standing, good kid. You know, if you've got one child that's good and three that aren't, it's not going to work real well. You put your one child in charge of everything, but you really can't trust the others, then you don't have that supervisory type thing. But yes, if you have, and in those cases, you already have the children that are probably going to do fine anyway, so that doesn't probably require the supervision. But, you know, because that's the one thing I want everybody to understand. What we're talking about is not the vast majority of cases, okay? I'm not sitting here telling you today that everybody needs to go home and look at your kids twice because they're probably up to something. That's not what we're saying, okay? The vast majority of these situations, you have very well-meaning kids who love their mom and dad, and they're doing the best they can in what's a very unpleasant situation. But what we are talking about is there are also instances where there aren't such well-meaning kids. And in those instances, how do you deal with it? And so that's really more what we're talking about here.
Build in though that the son A has to give daughter B a report every 6 months, or the daughter B can look at
So
the man that's
can we
bank
talk
account.
about that maybe at the end? I can do
Yeah,
a
whenever you
question.
want.
Okay, yeah, thank you. All right, so Yeah, you said that most adult children have, the best interests at heart of that. But, what happens when you don't have anything in writing in the guidelines, you're working in the dark there. So.
Right. The beauty of your legal documents, okay, is if you do your legal documents, you have a great deal of flexibility to put in the guardrails of what you want done. So things like supervisory provisions or reports or when you get to do certain things or don't do other things can all be in your legal documents. So when we're doing this type of planning, we go through what we call design meeting phase, where we have conversations with our families and we're trying to elicit what should we be putting into these documents, and every case could be different, okay? You might need much more protective type language that restricts the power of attorney in one case than you would in another. But how you draft your documents is a factor of what they do. One of the things that I always tell people is power of attorney, trust, those are words like vehicle, okay? So if you think about a vehicle, you can have a Corvette or you can have an F-150 pickup truck. They're both vehicles, but they accomplish two very, very different things. And when you talk about a trust or you talk about a power of attorney, the underlying language in those documents is what determines how they work, not the name trust, okay? Not the name power of attorney. I can have a power of attorney that gives just a very, very little amount of power, or I can have a power of attorney that gives everything under the sun.
And you're saying you can customize it.
You
I mean, a lot of us
absolutely
have similar situations, but there's a lot of unique things that
Sure.
everybody has.
Sure.
Yeah.
And I think customization is part of the planning in advance. It is so that you do take, at the end of the day, if you've done your legal planning correctly, what you're really trying to achieve is whatever your wish is, whatever you want to happen, okay? And if you want, like I had a client come in the other day, and he wanted to make sure that the house went to his daughter, because she lives in it, and he wanted to make sure that this other thing went somewhere else. That's all part of your plan. You put that all in there and it spells it out. So if you think, when I talk about roadmap, what I really mean is the way your documents read is they're telling the people in charge, when this happens, you're doing this. When this happens, you're doing this. When this happens, you're doing this. And so that's what that roadmap is. There shouldn't be a bunch of ambiguity. It should be pretty clear what's going to happen. Ambiguity is the enemy of this process because that's when people start fighting.
Absolutely. I mean, I know I'm very thankful that people that I'm involved with and family, have these plans already drafted up. So, I know, what I need to do, and I'm not going to have to argue with other family members. I'm going to say, this is what they wanted.
Yeah, and that's exactly the thing. That it shouldn't be when you're the trustee. It's very easy. When somebody says, but I was supposed to, right here, you can read it. The house went to Sarah. That's where it goes. No questions. Okay? One of the things so there's all these programs that try to teach attorneys how to be better business owners and that. And one of the things they've always tried to tell us to do is, you should communicate that doing your estate plan is a gift to your children. Okay? I've never done it because I think it sounds extremely hokey, but to a certain extent, you really are giving your children a gift. You're making it easier and you're taking out the fighting, because even the best families don't always get along during this process. And if you've said this goes to this person, then you don't have to worry about it. I mean, if you've got a family business, if you've got a vacation property, if you've got hunting ground, all those types of things, could end up being a problem. We had a client one time. The client had, the husband had played a smattering, a tiny little bit of professional baseball. Not hardly any, okay? He had played a whole bunch of like AAA, minor league baseball. And so when he was done, they built this collage. And it's got jerseys, it's got contracts, it's got baseball cards, it's got gloves, all kinds of stuff. Do you know how much it's worth to me? Nothing. I've never heard of the guy other than he's a client, okay? But do you know how much it is worth to those kids? It's almost priceless. There's 6 of them. How many do you think want it? All 6, okay? That is going to be the subject of potential issues when mom and dad are gone. And so you can take advantage, or not advantage, but you can take ownership of that and resolve all that by how you set up your plan.
So I know we've kind of been talking about adult children, but it can be anybody that could be in a
Absolutely.
situation that they're.
Yeah, we talk about children, I think, because that is where most people look, okay? But you could have a niece, you could have a brother, you could have a friend, anybody. There's bad and good everywhere. I think that's one of the things that you have to recognize is, not everybody has your best interests at heart. And that could be one of your children, or that could be somebody you go to church with, or it could be somebody that you grew up with. It doesn't mean they're going to do right by you.
So one of the things that I dealt with, my parents went through all this planning and everything, and then my mom did some things as she got less mentally capable that actually were not good things. They kind of went against the trust, so I've had to go back and correct them. So co-ownership. Can you speak to that? Because that sounds like a great solution for everything.
Yeah, actually, co-ownership is a way that a lot of people try to avoid doing estate planning. Easy enough. I'll just put somebody's name on my house or my account. I will tell you that I cannot think of a single time in 20 plus years that I practiced law where I've ever thought that was a good idea. In fact, I would sit here and tell you that's a terrible idea, okay? What people don't understand is the effects that has. So if we have a financial power of attorney in place, if we have a trust in place, they're held to a fiduciary standard, okay? They're supposed to be doing what's in your best interest. But instead, let's say you do what a lady did that came up at one of these workshops years ago, and she asked me a question afterwards. She said, I put my son's name on my account, okay, because I wanted to make it easier. And he took out $50,000 and bought a new truck. What can I do? Not a thing. When you put somebody on your account, you made them a co-owner. That means they don't owe you any standard of anything. They could take every dollar out of your account and do whatever they want with it. Okay? It is not a good idea to do. Let's say you don't have a bad kid, okay? Because I don't think that's the vast majority of cases. What if your child has a car wreck and they get sued? Do you know what part of the assets that they're going to come after are? That child's home that your name happens to be on. Your bank account that child's name is on. What if they don't have that? What if they get a divorce? What if they get sick? All those types of things happen in real life. So you don't have to have a bad child. You could have just unfortunate circumstances. And by putting someone's name on the account, you can cost yourself lots. So the lady that I met with, I had to tell her, unfortunately, there's nothing you can do. He could buy that truck. And so her nest question obviously was, what do I do? And so here's one of the weird things you're going to find out. It's very easy to put the son's name on the account. You know what's not easy? Getting it off. Because he doesn't really see a need for it to come off. So he's not going to work with you to do that. So what I told her was, you need to leave this workshop and go get all the money out of your account. And she said, well, why would I do that? And I said, because what if he decides he needs new tires? Because that's where he's going to go get the money from. So I would never recommend it from that. But there's one more reason that probably nobody here has thought about. Is anybody familiar with how a house functions when you sell it? So if you think about a house, let's say that we have a house, and Tom in here put my name on his house, okay? And so Tom bought that house 20 years ago for $100,000. And now he has Stephanie sell it, and she sells it for $300,000, does a great job for him. So Tom made what? $200,000, okay? That is what's referred to as a capital gain. You know who wants to get their share of a capital gain? Your uncle, Sam. He wants his share, okay? Now, here's the good news. The IRS has an exclusion, and you get to exclude up to $250,000 of capital gain if you sell your personal residence. So Tom is not going to pay that capital gain because he gets to exclude it. But let's say that Tom doesn't sell the house and he passes away, and now that house becomes mine, all right? The house is still worth $300,000. Tom still paid $100,000 for it, but I've got a house, so it's not my primary residence. So when I go to sell it, and I recognize a $200,000 gain, I don't get to exclude it because it's not my primary residence. And so now I'm going to pay somewhere between 15 and 20% capital gains tax on that $200,000 gain, somewhere between $30,000 and $40,000, because Tom put my name on his house.
And he thought he was doing a good thing.
He absolutely thought he was doing a good
Picking on
thing.
Tom, but sorry. And so like my mom, she was like, she started putting my name on everything. And I kind of went with it. And then when I got into the legal everything, reviewing all her documents, I'm like, well, this is going to be a problem. I can't be on here. It's going to be a problem in many different ways.
Well,
so then I had to go back and reverse
and undo
things.
it, right? Yeah, and if you think about it, let's say you have an IRA, okay, and mom puts, you're my favorite child, I trust you, I'm just going to make it easy. I'm going to give the whole IRA to you. But if you have 3 siblings and they're supposed to get some, that's a problem, because an IRA is a taxable asset. We inherited. So now if you're supposed to divide it up, you've got to pay all the taxes and then divide it up. Well, your kids are going to look at the big number before taxes and say, I'm supposed to get $100,000. They're not going to necessarily say, oh, but you know, Stephanie, you had to pay $30,000 in taxes on that 100. I should only get 70. And so it ends up in a fight because they feel like Stephanie didn't treat them properly. She took all mom's IRA money. That was not what mom wanted. She wanted her share. But they don't look at the tax piece of it. Same way with like the planning for Tom. If Tom had put that home in a revocable trust so that it still came to me without probate, you know what the difference would be? There's a concept called step up in basis. So on the date Tom passes away, we revalue the home. The value becomes $300,000. That becomes my basis, and I now pay 0 capital gains tax. So the planning is very important, and doing it right is very important, because you can lose so much money in so many different ways if you don't pay attention to what you're doing, that it's really just something that you got to get all your T's crossed and your I's dotted.
So maintaining control. So can we talk about, just real quick, what springing powers are? I don't think we talked about that. And how is incapacity determined?
So when you set up your documents, if you are not ready for anybody to be in your business, okay, you don't want to do what's called immediate powers. Immediate powers is boom, you sign the document, they can start doing something. You would do something called springing powers. And a springing power means the document's valid, it's in place, but until some future event, the people don't have any authority. So a typical springing power that most people use is what's called a one doctor standard. In other words, I got to get a doctor's note that says Tom can't handle his financial or his medical affairs. Now I can start making decisions. But until I get that note, I don't get to make any decisions. You, in designing your documents, can create whatever springing provision you want. It could be one doctor standard, or it could be something like a disability panel where you pick people and you say, these 3 people have to agree that I'm not able to do it. That could be your brother, your CPA, and your pastor, or your doctor, or whoever you want. And so that, again, is where however you design your documents is however they're going to work.
Yeah, and that goes to the customization, so awesome. Okay, customizing control. Did we touch on all of this?
We haven't talked about limiting the powers. I think that's probably something that's worth a touch. So the other thing to keep in mind is when we are doing planning, especially us, because we're worried about not just estate planning at our firm, we want to keep the government from taking things, okay? I am not a fan of how the government spends my money, and so I try to make sure they don't spend my clients' money either. And so part of that process, though, then requires you to put more advanced powers in your document. With more advanced powers, there's a certain more advanced risk. So how would you deal with that? Well, one of the ways you could do it is by limiting who can do it. So if I've got a married couple, Tom, and they say, if one of us gets sick, we want to make sure it's protected for the other one, okay? But you know what? Our kids are fine. We don't need to worry about them. Then what we're going to do is we're going to put all the asset protection language so that it can be applied to either of them, but not on down to the kids. That's going to protect against some of those risks that we're talking about, but it's going to make sure that if Tom has to go into long-term care, they don't take 80% of the assets and spend them down on the cost of care. So those powers can be limited from the very beginning as to who can use them or who can they be applied to.
Okay, awesome. So again, that can be tailored
Absolutely.
in the plan. Okay. Revocable trust versus irrevocable trust.
Sure.
Can you speak on that for a minute?
So when you talk to most people, I would say the vast majority of people, if they have a trust or they're familiar with trust, it's a revocable trust. A revocable trust is what originally emanated from estate planning. It's basically a way to make sure you avoid probate, but you stay in control of everything for as long as possible, okay? We use them and we put in what we call community spousal protection language to protect assets. That's the way we protect spouses if one of them gets sick. But not everybody does that. That's kind of a specialization. You have to be going to somebody who does more of the asset protection. An irrevocable trust is much, much different, okay? With an irrevocable trust, you're taking things out of your name and you're putting them into a trust that is saying it's not yours, okay? You're doing that because you want to protect it. So I'll give you an example. I'm homeless, okay? Now, I say that just to get your attention, but on paper, I don't own a home, okay? I have an irrevocable trust that owns all of our homes. Why? Because I don't want anybody taking any of those homes. So if I have a car wreck and something happens to me and I get sued, they can't touch any of our homes because I don't own them. So the irrevocable trust provides protection. It's a level of protection that's different than even in a basic revocable trust. But here's the issue. You have to give up control. And you're putting that control in somebody else's hands. Normally that's your child or children. And you're then hopefully going to be able to get them to do whatever you want to do. That's the idea, that you really didn't give up total control, you just gave up direct control. All right?
So that sounds more like, somebody who has a lot of assets and is, more on the wealthy side.
I would say it doesn't have to be wealthy, it could be asset mix too. So, I would say that from, our cases, based on our practice, most of our clients that own a home and have financial assets, it's going to be revocable trust with community spousal protection language, okay? The irrevocable trust clients are going to be the ones that have other things. So you can protect one home pretty straightforward. If you have a second home, that's at risk. If you have a vacation property, if you have hunting ground, if you have a vacant lot, those would be at risk. And at that point is when you would entertain, is an irrevocable trust an important strategy? Now, if you're not worried about protecting them or you don't have anybody you can trust, no, you don't do an irrevocable trust.
Okay. So let's talk more specifically about the asset protection planning. So does a basic plan give you all the protection that you need?
No. So if you go and you get a basic estate plan, so you get basic financial powers of attorney, basic healthcare power of attorney, basic trust, that's going to avoid probate. It's going to take care of incapacity, but it's going to do nothing for protecting your assets. Okay. In fact, it may actually stop you from protecting your assets. You have to go into this knowing that you want to protect your assets. So one of the conversations that we have with our potential clients is, what's important to you? If you don't care about protecting your assets, then you don't need that type of stuff in your documents. But if you are like a lot of our clients and you say, well, absolutely, if I get sick, I want to make sure my wife isn't sitting in the dark eating rice cakes, then you do want that type of language in there. And we get a lot of clients who say, well, why did nobody ever tell me about this? And the reason is, and it's kind of a phenomenon we were just talking about, there's not that many people who do estate planning and elder law and asset protection. Now, in the area where my office is, there's an unusual concentration of them. But if you get outside of that area, 99% of the people you go by do very basic estate planning, okay? They probably are doing something else on Wednesday and on Friday, and that's just a part of keeping the lights on. That doesn't make them bad. It doesn't make them wrong. It makes them what they do. And so they don't even know how to tell you what these other provisions are because it's not in their skill set.
So what's the number one thing that most people are trying to, protect from?
I think that we get two things that I would say most of our clients are going to tell us. Now, that may be because of who we talk with, okay? So in our client practice, our clients are almost all 50 and up, okay? We don't get a lot of clients younger than that. So our clients are going to tell us two things. Number one, they're going to say, we want to make things easy for fill in the blank. Our children, my siblings, whoever is going to be the ones taking over and getting things, okay? Then the second thing that we get, especially for married couples, is if one of us gets sick, we don't want them taking it all. Because when my dad got sick, they basically told my mom, who was 68 at the time, we want 78% of your assets. So she was expected to live the rest of her life after giving away, well, not giving away, but spending on long-term care, 78% of everything they worked their whole life for. Which, in my opinion, is ridiculous, okay? Didn't happen. Don't worry, she was fine. Your son's an elder lawyer, that better not happen, okay? But that would have happened if she didn't know and have that information.
So protecting from the long-term care costs is,
I think it's very big in married couples. It's when you get a single person, it's not quite as much. I think it's part of that's a misconception. When you talk to a single person, they look at it sometimes as if this is just about getting stuff to my kids, okay? And I don't actually think that's the only thing you need to think of it like. Married couples almost always get it. It's like, nope, we want to protect each other. In fact, I can't think of a single meeting where they didn't say that. So even if one of them didn't mean it, they weren't going to say it in front of the other one. So they were still going to say, yes, we want to protect it. But when you talk about a single person, one of the things that I think people don't understand is if you spend everything you have and you get down to $6,068, which is the exemption amount in Missouri, they don't pay for everything when they take over. So if you lose your hearing aids, you're just not going to be able to hear. If somebody, and this is the truth, this is gross, but if somebody takes your false teeth and there's people walking around nursing homes left and right with other people's false teeth, they're not going to pay for it. And so having money set aside, in my mind, is first designed to protect you. Now, if God willing, some of that's left over and it goes to your kids, that's great, but you can go to whoever you want. You can give it to charity for all I care. But having it set aside so you're not absolutely destitute economically is about making sure that you get false teeth, you get a new TV, you get a lift chair, you get whatever it is that you need, hearing aids, so that you can continue in the best way you can.
So we're specifically talking about with this asset protection, long-term care, being able to save money for the other party in a married couple, but it applies to singles too. We're talking about qualifying for Medicaid.
Mm-hmm.
Is that right?
That's right.
Okay, all right. And so we're going to give a few examples about how there are things that are legal to use to your advantage in that situation. So, so as far as, how does Medicaid work as far as assets and what assets they consider that they can take, or you have to do a spend down? Can you kind of go over that?
So Medicaid at the outset divides your assets into two categories. One is called exempt, one is called countable, okay? Now, here's a word of caution. If you take nothing away from this today, understand that the word exempt does not mean safe. It means they won't force you to sell it right away and use it on your cost of care. But that does not mean they won't come after your house later. It does not mean they won't come after your cars later. All that they will come after, okay? But the exemption means as of the date you apply, they'll let you keep the house. They won't let you pay for it. All your money has to go to the nursing home, but you can keep the house, okay? And so your house is exempt, your car is exempt. When they talk about a funeral, if you prepay your funeral and it's irrevocable, it's exempt. If it's not, they will tell you to cash it in and use it on your cost of care. Household goods, that's exempt. Then assets transferred to another name. That's like putting it in an irrevocable trust or giving it to a family member, okay? Those they can't get to. Everything else is countable. Your checking, your savings, your money markets, your IRAs, your 401ks, your 403bs, your hunting ground, your vacation homes, whatever it is. And so what happens is they're going to add up all of those countable assets and they're going to come up with a number, whatever that number is. And if you're a single person, you're only allowed to keep $6,068. So whatever that is greater than $6,068 would be considered your spend down. And if you are a married couple, then the additional spouse, the healthy spouse, called the community spouse, is allowed to keep somewhere between $31,500 up to a high of about $158,000. Everything above that has to be spent down.
So
Dollars.
does that
Sorry.
mean basically you have $6,000 to use for the rest of your life, or how?
That's exactly what it means. So if the first month after my mom didn't go to the nursing home, but let's say she did here, she went into the nursing home, her hearing aids were $8,000. She loses them, puts them through the dishwashing machine because she leaves them on her dinner tray. They don't work. She can't hear at all. She's not good at hearing. And so we had to buy her new ones. Well, there goes her $6,000 because it costs $8,000 to buy hearing aids. She has nothing now.
Wow, okay, all right. So speak a little bit more about the spend down. I think, here's the numbers that you were talking about.
Yeah, so this is actually the calculation. So what we're just showing you there in a picture is how this works. Down below where I wrote in red is really, I think, the point from this slide to take away. Let's go back to Jim and Linda. So when Jim was in and out of the nursing home, and she was looking to get assistance because it's about $12,000 a month, one of the things that's going to happen is they're going to tell her about this spend down, okay? Now, assume she doesn't have a son that's an elder lawyer, because we would make that spend down go away. But if she didn't, what I always tell people is, if you're trying to do this on your own, if you don't have somebody who's helping you, you've got to think. Make sure you use your money effectively. This is where people make mistakes. So if Linda has a home, but it's got a mortgage on it, should she write a check to the nursing home or pay off her mortgage? She should pay off her mortgage, okay? People think that if they pay off their mortgage, that's going to subject them to a penalty period. It is not. The penalty period is not if you're paying a valid bill. It doesn't have anything to do with it. So what if she doesn't have a mortgage, but what if she has a house that's 30 years old and her HVAC system was put in when it was built? Still works fine, okay? I would still suggest replacing it. The reason? Because after you spend all that money down and you then 2 years later have an HVAC problem and they want $17,000 for it, they're not going to give you any of that money back. And it's going to come out of the little bit they let you keep. So pay it now. It cuts down on what you have to spend down. So that's what I'm talking about here when I say think before you start writing checks. You have a lot of options, but people tend to get like horses with blinders on and think, I just write a check, I write a check, and eventually it'll all go away. At $12,000 a month, it goes away much faster than you think. And then you will get approved, but you have very little left to protect yourself.
And I don't know if you need to go over this slide or not, but I definitely heard you say something about, well, you can avoid the spend down.
Mm-hmm.
So I definitely want you to speak upon that. How
Sure.
does that happen?
So what happens is, with the spend down, everyone has to do a division of assets. And this is what a division of assets looks like. So this is where we're talking about the numbers early. Bill and Susan, that's not their real name. But this comes from a real case we did several years ago. And so they came in, Bill was sick. And so they have to do the division of assets. And basically they split the money between them. Half goes to Bill, who's the institutionalized spouse, half goes to Susan. That calculates the spend down, okay? So what they're telling Bill and Susan is we want $446,762. That's what they want, 73% of her assets. Now, this is fundamentally where things change if you've gone to somebody who does the asset protection planning. Because the community spousal language that's designed to protect it is going to allow us to take that $446,000 and instead of spending it down, set it up so that it all goes to Susan. Okay? And so in a typical case like this, our expectation would be Susan loses nothing. Just as Linda, my mom, lost nothing. Okay? My dad got immediately onto Medicaid and got assistance. My mom kept every dollar, even though they said they wanted most of her money. In this case, Susan kept every dollar. And so one of the first things that you typically are going to do in these scenarios is you're going to move the house out of their joint names into just the name of Susan. You're going to then take these other assets that are spend down and you're going to set it up in a way that they can't take it away from you. And so that is really where that asset protection language comes into play. When we talk about putting it in there, it's so that we can take these steps, okay? So one of the things that people don't understand is if you have a basic estate planning document, let's say you've got a financial power of attorney. Now we need to move the house out of Bill's name and into Susan's name, okay? That's a gift. Even though they're married, this law says that's a gift. And unless your house is very small, very little expense, that's a problem because most of your financial powers of attorney that are basic estate planning attorneys or estate planning documents are going to say that you can give away up to the annual exclusion. Anybody know what that is? It's $19,000. So if you have a $38,000 house, you're good. You can still protect it. If it's more than $38,000, you can't move the house. And they're going to be able to file a lien against it and come after it. So it's very important to have the right language in there to be able to protect assets. That's what we're doing for our clients in their 50s. We're getting that language into their documents.
And you know, anybody who's here who owns a home, it's definitely worth more than $38,000.
I don't think I've seen a $38,000 home yet.
Okay, so this was about how you can avoid the spend down. I think one of the big things I heard is that the basic estate planning documents don't work for this. This is a whole nother
Yeah, so what happens is
documentation. What do you call this?
it's the same document,
Okay.
but we take where you had just the basic estate planning language, then now we infuse this asset protection language. So that's what we call community spousal protection language. And so what that does is that takes where the traditional power of attorney limits your gifting to $19,000. Ours would have a provision in it that said, but you can make unlimited gifts if you're planning for long-term care. Or where a traditional power of attorney would say, you're not supposed to give money to yourself using this power of attorney. That's called self-dealing. Well, the problem is, if that's your spouse and we're trying to give the money to them, we can't have a self-dealing limitation or they can't protect themselves. So again, you want your powers of attorney to not provide that provision. You want it to say it can engage, or the person can engage in self-dealing if we're talking about a situation where long-term care planning is needed.
Okay, so it puts back in some additional language and rights.
Right.
Okay, thank you. Talked about community spouse protection language.
And so here's what, actually this is the actual, so this is Bill and Susan again. So this is showing you what you can do. So you've got the same spend down amount here, that $446,000. But what we're doing there is we're actually taking that $446,000 and we're creating something called a Medicaid compliant promissory note. Very much a specialized document. But what it does is it makes that $446,000 disappear. And now what happens is Tom's sick, but Linda loans that money to me, her son, and I pay it back to her, okay? It's not a gift because she loaned it to me, and it follows the terms of Medicaid compliant promissory note, and when I pay it back to her, she gets to keep it, okay? So now Tom would be immediately eligible for Medicaid, and we don't have to spend down.
He would immediately
Be eligible for Medicaid. And what happens is, and this is a very important part, the community spouse's assets can only be looked at on what's called the snapshot date. That's the date of application. So on the date of application, we just finished making this loan. That money's not there. her assets are just fine. She qualifies and he qualifies. He gets approved. The day after, I write her a check for $10,000. That's her first check, and I pay that money back just as fast as I can, okay? She gets all of her money back. She didn't lose any of it. That's the kind of things that those documents are going to allow you to do, and that's how you protect the assets in that setting.
But you have to know, and you have to do it in the right order.
You have to know, you have to do it in the right order. And the other thing, the reason I preach the importance of getting that language in there is because probably once or twice a month, somebody will come in and they'll have a similar situation, and the problem is their Tom has no idea what's going on and can't sign documents anymore, and all they have is estate planning documents. And what I have to tell them is, you can't protect the assets. You don't have the powers.
So this was all talking about like proactive pre-planning, okay? So what about when you're not in that mode and it's crisis planning?
So crisis planning for a married couple, as long as we've got the right language in there, we're not worried about it. I mean, we obviously we don't wish it on anybody because it's unpleasant. But if you're a single person, as long as you have the right language in there, your expectation is you can protect about 60 to 70 cents of every dollar you have. So even in the worst case, if asset protection is a goal, you should be able to protect it, even if it's just for yourself. So really, it just boils down to the situation. My biggest takeaway, if I was giving one, is that you have to first know what's important to you, okay? Just because I say it doesn't mean it's important to you. It's whatever's important to you is whatever's important to you. And if you're saying, I want to make sure that if I get sick, I don't want all this being taken away, then you want this kind of language in there, and then somebody like us is going to be able to walk you through the exact steps to make sure that whatever you're trying to get protected gets protected.
Okay, so this was an example of Bob, who had a family, and that they weren't proactive. They didn't do the advanced planning.
Yeah, so in Bob's case, he hadn't moved any money. Bob, this is actually a real case as well. This is actually the one with the numbers you were asking about. And so this happened a couple years ago. And so what happened is he was his niece's wedding, and while dancing, he has a stroke. Okay, and so Bob's statement to his kids is, I want you to get this money protected, okay? Now, fortunately, Bob could still sign documents with his left hand. I was right, because he had paralysis. So that's fine, doesn't matter if your signature's bad, you have to be able to sign. And so when we got the powers in place, we're able to protect about 2/3 of his assets. It's done the same way. You take that money, okay, and now because we have a new financial power of attorney in place, if this was Bob, he can make a transfer, I can, as his trustee or his power of attorney to myself. It doesn't violate the 19,000 because the power of attorney we designed allows it. It doesn't violate self-dealing. That money is now out of his name, okay? So the state can't get it. Now, we do have to deal with what's called the look back and penalty period. That's why you can't protect all that money. So you have to leave some money in place to make sure you can pay through the look back or penalty period. And so that's one of the cautions I give to everyone is, don't just simply give everything away and say, "Ooh, I fixed it." That does not work, because they're going to hit you with a penalty period, and if you don't have the money to pay at the nursing home, that's not a good outcome, because they're going to give you a penalty period from the state, and you will not be able to pay for it if you're not careful.
Yeah, exactly. So again, doing things in advance, and in that same example, luckily, he was able to still take control over some things, and that's
he could sign.
not always the case.
You know, I mean, his issues were not cognitive; they were physical. He couldn't walk, he couldn't bear a lot of weight, but he could still use his left hand to some degree. Had he been cognitively not there, we couldn't have done that. He would have lost the money, and that's why getting the documents in place, being proactive, not so much in moving money, but in getting your language the way you want it, I think is important.
Yeah, and we never know when these things are going to happen, right?
Right. You don't.
Yeah.
I mean, obviously, if you have a diagnosis and you see someone get sick, you can kind of see and you know the normal time horizon. But the strokes at a wedding, those types of things, nobody has any idea those are coming.
And this was just speaking again about the home protection, the exemption of that.
Yeah, I think it's one of the things that if I was to tell you what do people find out and regret the most, it's probably the home exemption. Because when you hear the word exempt, like I said, they think it's safe. Well, that's not what it means. So if you think about, a situation where you've got a married couple, and let's say that the husband has to move into the nursing home, and he's there for a period of 12 months, and they rely on the exemption. And then the wife says, you know what, I'm gonna need to downsize. This home's too big. I can't take care of all this home. And so the wife goes and she goes and sells it. All right. Who does the check come to? Well, more than likely that home's owned jointly. And so that means the person in the nursing home has a portion of those proceeds. Well, what you don't know, or maybe you know this, but what most people don't know is when you go into long-term care and they're assisting you, they're keeping a tab every dollar they spend. And so over the course of a year, if they've spent $150,000, you owe them that. So when that check comes from the home's proceeds, the state's going to be raising their hand saying, you owe us $150,000 out of his side. And with what's left, that gets added to whatever he has. And if he's above $6,068, he's going to get kicked off Medicaid until he gets back down below it. So here's a tip. This is something you want to know. If your power of attorney allowed transfers right before that individual went into the nursing home, we would transfer that home out of their joint names and into just the name of the healthy spouse. Typically, we put it in a trust to avoid probate. Why? Now, if she sells the home, who does the check come to? Just her. She gets all the money. Her assets aren't relevant anymore. It's already past the date of application. Yes?
Doesn't Medicaid do a look back? Doesn't it possibly do that? Isn't it like 5 years?
Medicaid does do a look back. It is 5 years, but it doesn't apply to marital couples. If it's a marital couple, you can move assets back and forth as much as you want. Now, if I would have given that house to their child, that's a look back penalty period issue. But when you transfer it just between husband and wife, it doesn't trigger anything.
What was that again?
She asked, doesn't that trigger the look back and penalty period? Okay, because normally, if you give it to your kids, it does. If you put it into an irrevocable trust, it does. If you give it to your spouse, not at all. That's a transfer between a marital unit, and that's considered one for purposes of Medicaid. Yes, ma'am.
You haven't mentioned a beneficiary.
So, I didn't mean
No, go ahead. No, it's fine. Yeah, let's do questions.
to. Honestly, it's because I don't like them. The reason I don't ever recommend beneficiary deed to our clients, and here's why. When you have someone who goes into long-term care, remember I told you they're going to keep your tab? One of the things that they'll do is they'll file something called a TEFRA lien. And so a TEFRA lien is basically them coming after your home later, okay? And so the problem I have with a beneficiary deed is there's case law in the state of Missouri where Missouri says that a beneficiary deed does not defeat a TEFRA lien. So you think you have this beneficiary deed and it's going to go to your kids, and you go into long-term care, and now your kids believe this. And we have people come into our office and they've mowed the grass, they paid the property taxes, they paid the insurance, they kept up all the house, and now they think they're going to get it, only to find out that this nursing home or the Medicaid agency has a $280,000 TEFRA lien against it. They don't get it. So I don't personally like to use them because I want to defeat the TEFRA lien. So I'm going to generally do something different than a beneficiary deed. Now, a beneficiary deed does have one good purpose. It avoids probate. But that's all it does. So if you're a firm like ours where you're trying to protect assets, it's not a tool we use very often.
Yeah, as long as you, I guess as long as you pass away.
Yeah, I mean, this goes back to the same thing I've said. You have to have your goals, not mine. If your only goal is I want to avoid probate, beneficiary deeds got you covered. If you said, but I don't really want to see them take it away either, then your beneficiary deed's not the route to go.
Yeah, and you never know what's going to happen, right? You don't know if you're going to.
The only person who knows doesn't share the plan with us.
Right, unfortunately, yeah. So did want to ask, what if you already are, you haven't done this and then you are in a nursing home? Is there things that you can still do to protect your assets?
As long as you can sign documents, yes. I mean, so, there's a certain amount of cases every year that they come in and they say, so-and-so is at rehab right now, they're not going to get to come home. Is there anything we can do? And first thing we're going to do is look at their documents, if they have any. Sometimes they don't even have any. More often than not, if they do have them, they're going to be basic estate planning documents, so they really are going to need to sign something new. At a minimum, if we can get a new financial power of attorney, which is going to be where a lot of those powers are located, then we usually are going to be able to protect a significant portion. If we can't, then it's pretty limited. You remember when we were going through the spin down slide and different spin down techniques? That's really where you'd have to turn your focus. Have you prepaid your funeral? Have you paid off the car? Have you done things that are not necessarily going to result in this huge savings, but they're going to be smarter ways to do things than if you didn't do anything.
Okay. So on one of these last slides here, it talks about powerless legal documents.
Mm-hmm.
And I think it is kind of explaining the difference between having an estate plan versus going through an elder law attorney who does additionally ask.
And that's exactly what it's designed to do. I mean, I would say that, and the other reason I brought it in this particular setting is because I think it also addresses the instances where the types of powers you want to give someone might be different, okay? So on the right-hand side, where we're saying yes to all this stuff, that's the much more advanced asset protection type language, okay? If that's my goal, is to protect assets, I want that type of power of attorney. If that's not my goal, then I probably want the more basic estate planning attorney. But if we go back and we rope that in with the idea of manipulative children, if I have no one I can trust, I'm probably not doing the elder law power of attorney, because that's given a lot more authority to people and I don't trust them. Okay, I'm probably going to stay over on that others column where it's more about paying bills, not protecting assets. And so I think that's the kind of the link into even what we're discussing here.
And so what about going into a nursing home? Can my child, if I'm giving them some rights, or whoever this person is that we give power of attorney, can they purposely put me into a nursing home when I don't want to go?
They can try. If you give somebody, so power of attorney for healthcare is the person who would have the power to admit you to a nursing home. Power of attorney for finance is the one who would pay the bill. There is a certain, yin and yang to that healthcare power of attorney decision. I don't really see it too often where somebody is being put in and they're being forced to stay in when they really shouldn't, okay? Where we actually see it is on the other side, where we've got people calling because their mom or dad, every time somebody's not at the house with them, they wander out in their pajamas. Winter, summer, doesn't matter, okay? So they're not really safe at home. And they want to put them into long-term care, but what you run into is a lot of people in the early stages of starting to decline, up and down. You talk to them in the morning, they're fine. You talk to them in the afternoon, they're not the same person. And so when you get in there, if the facility believes that person knows what they're doing, they're not going to keep them. They're going to say, okay, yeah, you can go home. So could somebody try to do it? Yeah, but if you've got some level of your faculties to you still, I would say most facilities are going to send you home against the child's wishes in a lot of cases.
Other questions?
Yes, ma'am.
Can you have two types of trust? Can you have an irrevocable and a revocable trust?
You can, I do. So to give you an example, we have a couple homes. They're in our irrevocable trust, but I don't want to put any of my financial assets in because I want to manage them day to day myself. Not me, I use a broker, but I want to be the one having that
You
conversation.
can put some of your, let's say you have two financial goals. You could have finance in both of them.
You can do anything you want. So what you're doing is you're deciding how much you want to wall off and protect versus how much you want to have in your name under your control. And so we have a lot of people who will come in and they'll do planning and they'll do both types of trusts and they'll only put certain assets in the irrevocable trust to start. especially if they're in their 50s or 60s. Now, if you're 85, it's probably not that great of an idea to piecemeal it in because you're so far up there by the time you do the rest of it, it doesn't really matter. But on the younger clients, yeah, that's very common.
So if I put some assets in an irrevocable trust
Mhm.
and put my kids' names in it,
Mhm.
that falls into the 5-year look back?
It does.
Okay, so I have to put it in just my name?
No,
I couldn't.
no, you would put it in their name. So I'll give you an example. Okay, so I have an uncle, and my uncle owns about 2,500 acres of farm ground around Rend Lake in southern Illinois. It's worth a lot of money, like crazy amounts of money. He's the typical farmer. We would call him dirt rich and cash poor. Okay, he was driving one of his cattle trucks, had some problems, went to the doctor, and they said you have Parkinson's. So he called us, and this has been probably 6 or 7 years ago, and he said, I have Parkinson's, I don't want to lose an acre of my ground ever. So we created an irrevocable trust, and we put his farm in the irrevocable trust. His son that is his co-farms with him is his trustee. Okay, now it has been 5 years. So if he goes to the nursing home tomorrow and says, I can't do this anymore, I need to come in, he will get immediate assistance, and they'll never touch an acre of ground.
But if you don't make it to those 5 years, let's
Correct.
say 3 years, and my husband has to go into a memory care facility,
Uh-huh.
then that irrevocable trust is part of the community asset?
Then you would have to explain that you made the transfer. It's not part of the community assets, it's a transfer, okay? And so what would happen is you always are going to figure out, whoever did this for you, the attorney, is going to figure out the fastest way to get somebody else to pay for this, the government, okay? So in my uncle's case, go back to his scenario, because his farm is so valuable, his penalty period, if he disclosed the transfer of it, would be like 700 months, okay? So if he was healthy for 3 years, and then in the last 2 years, he had to go in the nursing home, what are you gonna do? Well, you're going to come up with the money to pay for those 2 years, okay? Now, he has an IRA, he has other assets that we could use, and we then, once we get past that 2-year window, we're now gonna go and we're gonna fill out that application, and on that application it says, have you made any gifts or transfers in the last 60 months? And what we're gonna say is, well, no, we transferred the farm 60 months and 1 day ago, so we don't have any. He's eligible for assistance and he gets it. Now, if he had to, we'd sell acreage. The least desirable acreage, you'd sell some and pay for that 2-year window, but he had other assets. So anytime we're doing planning, okay, we always know how we would pay the penalty period if we had to. So we don't do this with like cross our fingers and hope, because that's not a good idea. We know before anything, if this goes wrong, this is what we're going to do. Yes, ma'am.
I'm starting to feel really lucky because I don't know how it's hardly any. I do have a question. Is there any way to leave money to a child who is on Medicaid
Yes.
without?
Without kicking them off of Medicaid, okay? So I'll give you 2 options, okay? Number 1 is you can create what's called a springing supplemental needs trust in your legal documents. And so what it says is, I leave this to my child, but I leave it to him in a supplemental needs trust. What a supplemental needs trust is, it's a federal law exception so that it's held in a way that the state and the federal government can't take it, okay? That is the easiest and cheapest way to do it, okay? Now, if you're wanting to leave him IRA money, then you can't use a springing supplemental needs trust because you have to be able to name the trust in these beneficiary documents, in which case you have to do what's called a standalone supplemental needs trust. Same type of trust, does the same thing, but it has to be created in its own trust. That answer you?
Irrevocable trust, so if you move like a piece of vacation home into an irrevocable trust and name each child as the trustee, are they then attached to any liability if something happens with them? Can that be?
Nope, that's the whole purpose behind a trust. It's one of the reasons. So if you go back to, I would never put a child's name on something, part of the reason is if they get in a car wreck, they sue for your asset. When you are a trustee, you don't own anything in the trust, you manage the trust. The trust owns it. One of the reasons the irrevocable trust is appealing to me is because no one owns any of my homes. The trust does. The trust doesn't drive a car. The trust doesn't get divorced. The trust never gets sick. So all the things that could happen to an individual don't happen to a trust. And so when I put those homes into that irrevocable trust, I basically made it so, short of, something unusual where somebody is, got a claim out of that house, nobody can touch them.
And then it also removes liability from me as far as like what happens on the property.
No, that's the one area you could have a problem. So if you take somebody to your property and they fall down the faulty stairs and sue you, that's assault. They can do that. So that's not something, because that would follow that piece of property anywhere. It doesn't matter how you own it. Yes, ma'am.
Okay, so, if you have a trust in both of your names, and one person is incapacitated, change the trust so I'm just the named trustee. Is it still partly in his name?
Yes. So.
Well, I would have to have a whole new trust.
Well, yes and no. I mean, if you're just talking about somebody becoming incapacitated,
Personal situation.
yeah, but if you're talking about just a situation where somebody becomes incapacitated, you don't even have to change the trust. It's set up to say, when both of us can't do it, the other one can, typically, okay? But if you're saying, okay, I'm gonna have to apply for Medicaid because of this individual situation, yes, because the trust was a joint trust, meaning everything in the trust is usually jointly owned. So when you're applying for Medicaid, anything that individual's name is on, they're going to look at it like their asset. So
If I put it in just my name, then it doesn't?
pretty much, yeah. I mean, it's a little more involved than that, but yes, that's the end result. So in our cases like this, when I'm doing this for my mom and dad, okay, we move the assets around and then they end up in my mom's revocable trust, not in my dad's name, and she keeps everything. Okay. Now, the one other thing I do want to say, because sometimes people think we're tricking the state or we're cheating them. Nothing we're doing is not within their rules. We actually spell out every single thing we do. So this is not us tricking the state. It's not us hiding stuff from the state. It's us saying, here's your exact rule book that says we can do this, and we show that to them in the application. Yes, you got it.
What about a residence trust?
Well, residence trust, I mean, that's hard for me to tell you the answer to that because a residence trust is just a name, okay? So it sounds to me like what you have is an elder council document where they do a residence trust and a non-grantor sub-trust. That's actually what we use. And that is usually an irrevocable trust designed to protect your home. So I would assume if it's been in there 5 years, your home is protected. But if I don't read the trust, I can't tell you that for sure.
What if one passes away?
It doesn't matter. You still get to live in the home. The way the elder docs, I think that's probably what you have. The way that the trust is written is you have what's called an equitable life estate, which means you have the absolute right to the beneficial use and enjoyment of it throughout your lifetime, or throughout your joint lifetime if it's you and your husband. So if one passes away, it doesn't change anything. The other one still gets to live there.
And what about Medicaid?
Well, if it's been in there 5 years, it's as if the home doesn't exist. It doesn't count. You can file for Medicaid, and they're not going to count the home at all. But if it hasn't been 5 years, it would be a potential issue.
Every state's different, right?
Yes and no. Medicaid is a federal program, okay, but every state implements their way of doing it differently, okay? So you could have differences between states, and actually California does whatever the hell they feel like. They have what they call Medi-Cal. They don't follow anybody's rules. But generally speaking, there's a general guideline that's set forth by the federal government, but there are significant differences even between Illinois and Missouri.
Do you see for, these guidelines changing so that you can't do the asset protection?
Most of the stuff that we're able to do would be very hard for them to change, okay? The stuff that everything you try to change like that has a corollary somewhere else that causes them problems, okay? And so a lot of this is really not stuff I expect to change. They talk every once in a while about changing the look-back period. You hear stories about it could go to 7 years, 10 years. I don't know how it could go to 10 because banking records are only kept for 7, so you couldn't even prove anything past the 7-year mark right now. The one area that I think is ripe for problems is there's a strategy that is really out of favor in Missouri particularly, and even in Illinois, is something called the name on the check rule. That's a strategy that's used a lot of times to try to protect IRA money. And that's an area where I think at some point they may try to change it.
We didn't even talk about that.
No, I mean, we could talk all day about all
Yeah, I know,
kinds of
but I'm
stuff.
just curious.
Yeah, it's just it's a way that, like, if I have a married couple, okay, and one of them has a bunch of IRA money, that's a problem asset because it belongs to that individual. If that's the person who gets sick, they're saying spend it down to $6,068. Well, with the name on the check rule, you're able to make that money disappear, have it be paid to the healthy spouse, because in Missouri, the healthy spouse's income is unlimited, so then they don't touch it, okay? But Missouri does not like that strategy. They do not care for it, as most states don't, because basically they're looking at a $500,000 IRA just disappear and show up over here and they can't get it. They don't like that. So that's an area where I could see them trying to change something or fight it.
Okay. All right, good to know.
Real quick, are there power of attorney forms that are available outside of the district attorney's office? And what makes them legal? What makes them legal?
Well, they have to be executed correctly, witness, things like that. So there are powers of attorney form that you can get. Most of them are just healthcare powers of attorney in Missouri. I don't know of any publicly available financial powers of attorney, but most hospitals, most places that are kind of not-for-profit healthcare-like places have the healthcare powers of attorney. You can also type in financial power of attorney on the internet. I mean, the problem you run into is the internet's looking at 50 states, and that doesn't necessarily mean what you get is going to be valid in your state, but there are ways to find it.
Regarding the codicil, like if you want to make a slight change in your will, can you type that document out and have it notarized and add it to your will, or does it have to go through an attorney?
So, could you do it on your own? Certainly. If you follow all the requirements, it's perfectly valid. You don't have to have an attorney. Would I recommend it? No, because if you miss one requirement, it's a waste of time. So,
Find out what the requirements are.
I mean, it's all statutory driven. Everything that an attorney does is driven by the Missouri statutes on what's a valid will, what's a valid codicil, what's all that kind of stuff. So you would have to do the research on it, again, online, you know, and you can pretty much find a lot of information online that'll say, okay, what do I need to do for a valid will codicil in Missouri? Okay, now 90% of it is going to include a line at the end because it's an attorney advertising saying, but you really should go see an attorney, and preferably me, and here's my address. So, but it does give you a lot of the information you might need.
I just don't, I have a couple of slight changes that I want to make, and I don't want to pay the money to have it done when I can do it myself.
I mean, certainly it's possible. I mean, I'm not going to tell you couldn't get it done. My experience has been a lot of times, though, if somebody does it and doesn't get it right, it just creates a mess.
I mean, what we did that versus writing a letter and having an envelope in your drawer, you know?
Well, the letter is completely not valid, doesn't have anything to do with it. So you cannot alter your legal documents by subsequent conversations or letters. You could actually get somebody, your loved ones, in trouble. So whoever you appointed as your personal representative, they're tasked with following whatever your will says. So if you go to them and say, no, don't do any of that, give it all to them, and they do that, everybody you listed on that will is going to sue them, and they're going to win.
Anything that complicated, okay, do something to get rid of a kid or something.
Yeah. I would just say, you know, risk versus reward.
Exactly.
You
It's
know,
one of those things that,
I
you know.
just don't know that it's worth risking.
There's no money involved, though.
Yeah, but
Personal item or something like that, but maybe.
Does your will not have a personal property memorandum?
I have to look and see, I've done that, it was so many years ago.
I mean, that if it's a personal item, that would be the first thing I'd be looking for is a personal property memorandum, because those are actually designed to be something you can manipulate forever, okay? I'm never going to tell someone you couldn't do it, okay, because that's self-serving. But I would say more often than not, when people do it, it doesn't work.
all right. Well, thank you very much, Steve. It's been wonderful. The asset protection, I think, it's a whole financial, legal nightmare. Well, you know.
That's the one thing I would say. If you get to the right places, part of the job is to make it easier, okay? So I like to think that when a client is working with us, it takes a lot of that stress and that burden off of it. And I'm not just talking about us, I'm talking about any of the guys who do this, for the most part, are gonna make this easier.
Yeah.
Okay.
You want an expert. You want an expert. You want somebody who specializes in this and that doesn't, somebody who doesn't fix traffic tickets and do all kinds of stuff like that. Because this is a very, this is a specialty, right?
I mean, if you have somebody who truly is saying they are an elder lawyer, they're not gonna be doing anything else. We don't do, I mean, if you came to me and said, I got this great personal injury case, I don't have a clue how to do it, okay? And none of these other guys or gals that do it are either. This is what you do, okay? Now, there's plenty of people who can do that, but then they're not going to be the ones who can really guide you through this piece of it.
All right. Well, how about a round of applause for Steve? So, and hopefully, if you can stick around for a few minutes, if anybody has any more specific information. Sharon has some further information that Steve brought. If you would like to take anything, you can grab it on your way out. So thanks for coming. Hope to see you all next year.
Happy holidays.